The professional responsibility question from July of 2008 is another challenging, difficult question. It's a short fact pattern, and it requires us to do all of our own work to organize the answer. Look at the call. What ethical violations, if any, has Alex committed? Discuss. Answer according to California and ABA authorities. And then, above that brief call of the question, we see 3 short paragraphs. And this fact pattern follows the standard that I've pointed out in other seminars, which is the shorter questions often are the more difficult. Here, before we even read the fact pattern, we know that we're going to have to be very careful about spotting issues. And going in, we will either be organizing around facts or around duties. And as it turns out, I sort of use a hybrid method. There's plenty of room for reasonable people to organize successful answers to this question differently from one another. Let's review the facts for a couple of minutes. Go to the top, and in paragraph 1, we meet Alex. And by the way, everything that we learn about Alex indicates that he's a pretty good guy. And it also indicates that these clients end up being properly served. So, Alex is not the sort of lawyer that we often meet in PR questions. The people who are busy stealing, seducing, lying, and breaching contracts. Alex appears to be somebody who's trying to do well. But as it turns out, his conduct is going to fall short of ethical standards. So, in paragraph 1, he agrees to form this partnership. There's a brief meeting. He agrees to do it for $5,000. Anytime we see a legal fee mentioned in a fact pattern, we ought to ask ourselves a basic question. Is it reasonable? So far, we don't really have a good way to tell whether or not $5,000 is reasonable for the work that's about to be performed. But it certainly is not outrageous on its face. Now, paragraph 2 provides us with important facts that we are going to have to very carefully and meticulously deal with. Here we have Alex hiring a recently disbarred attorney named Dale as a paralegal. And this guy has got plenty of experience, which Alex lacks. And here in paragraph 2, we see Alex trying to be a good guy and trying to do the right thing. He notifies both the state bar and his clients about what he's doing. So Alex is not trying to cover up or explain away his own lack of experience. He's trying to obtain the experience that he lacks by hiring someone who's got the experience. Now, go to paragraph 3, and here we find out how much work both Alex and Dale did to complete this partnership agreement. Now, one thing that we don't see here in paragraph 3 is that there's anything wrong with the agreement. Everything about this fact pattern suggests that these clients have obtained the benefit of their bargain. So, our question is a somewhat more academic one, which I think makes this question harder. In real life, the state bar would never find out about this case, other than hearing from Alex that this disbarred attorney Dale was getting a little bit of work in Alex's law office. So, turn the page and have a look at how I have organized my answer to this question. And again, you'll see this is one of the shortest and least detailed outlines of any that I write for any fact pattern. And the reason for that is this question does not lend itself to breaking down into finer detail. Now, I was tempted to organize this answer chronologically. Just follow everything that Alex did and then judge whether or not it was an ethical violation. And I think a lot of successful answers were done that way. But the reason I have done it the way that I have is because I think this organization gives me a chance to go a little bit further in depth and do the analysis that I think really can justify the highest score. So turn now, please, to consider the answer that I present. And I think you'll see instantly that this is one of the least fragmented answers in the entire master essay method set. There are almost no internal headings here. This answer is thick on analysis, which I think is the most effective way to respond to fact patterns that are presented this way. So, as we look at what I have to say about the duty of competence, we see that my basic criticism of this lawyer's work is that he didn't know what he was doing. He should have become competent himself. He should have done something like, for example, consult with Dale and also do some library or other research work on his own without charging the clients for that effort. Because an attorney can take on a case that he or she is not competent to handle so long as the attorney becomes competent before it really matters. And so here, it seems to me that technically Alex was not competent and never became competent to handle this partnership matter. And there's nothing about any distinctions between California and the American Bar Association that make this any more complicated. So take a look at my analysis in these 5 paragraphs, and you'll see that in each one I'm trying to explain how the facts and the law relate to one another. And also notice in the 4th paragraph that I point out that it looks as if Booker and Claire, the clients, actually received competent professional services. But still, technically, our lawyer Alex wasn't ready to do the job and he never became competent. Next, I turn to the duty of loyalty. And really, the only reason to bring this up at all is because we've got an attorney who is taking on 2 individuals and representing both of them in the same matter. Now, it seems to me that this is an entirely legitimate thing for Alex to do, given the situation that these clients are presenting. Both of them are coming to form a business together. So I don't make this any more complicated than it is. And I don't think that there are any facts that really support a breach of the duty of loyalty. It isn't as if Alex takes care of one client over the other. Now, the meat of this question, the hardest part of this fact pattern, deals with the employment of this disbarred attorney. And the reason why this is the most difficult part of the question is because there is a split between California and the ABA. And, as usual, the California approach to this issue is more liberal than the ABA. Basically, the American Bar Association says disbarred attorneys have got to just get away from the legal profession altogether, regardless of what it does to their standard of living and regardless of whether or not they might have something to contribute. And the rationale is pretty easy to understand. The ABA says an attorney that has been disbarred gives an appearance of impropriety to any other law office that he or she ever has anything to do with. Now, that makes sense, but it is not a widely held standard across the country. Most states have more liberal interpretations than the ABA standard, and I think the rationale for that is clear also. We don't want to add to pressures on the social welfare system by completely destroying the careers of disbarred attorneys. So, the California standard is to allow disbarred attorneys to work in the legal field so long as appropriate disclosures are made. So, here, any ethical violation that Alex makes is mitigated by the fact that he disclosed his relationship properly. But the problem that I have with the conduct of Alex with regard to Dale, even in the California standard, is this. Because Alex never became competent in this area of law himself, Dale actively was practicing law in this case, and that's not acceptable for a disbarred attorney. And the burden is on Alex to make sure that Dale does not practice law. Now, personally, I don't think Alex would have had to do a great deal to become sufficiently competent to manage Dale. But he failed to take those steps. And so, again, technically, although this guy did do what he was supposed to do with regard to giving proper notice, he failed to do what he was supposed to do on a more fundamental level, which was actually be fully in charge of the case. Next, we turn to the fees. And the reason that I talk about the fees here is because I'm just going chronologically through the question. So I easily could have organized this answer in a strictly chronological fashion. But I think the fact that this attorney never became competent makes that appropriate lead heading. There are plenty of other legitimate ways to go about it. So, turning finally to the fees, it seems to me that here there are no relevant distinctions between the American Bar Association standard and the California standard. Now, reasonable people can differ. I look at this situation and I just don't think it's outrageous to charge this much money. I know many lawyers that would charge a lot less than that, but I don't think that it's extreme and outrageous on its face. But again, as we look more closely into it, the fee is not reasonable either, because the guy who was actually practicing law here got paid less than the figurehead who's presiding over somebody else doing the real legal work. That's just not acceptable under the ABA standard or here in California. So take a look at the conclusion, and as is occasionally the case here in professional responsibility, I write a fairly elaborate, long conclusions. And this is a much longer conclusion than most of the conclusions I write for subjects like torts or contracts or property or remedies. Here, I think writing a really fluent, fairly comprehensive conclusion that is directly responsive to the call of the question is the strongest way to answer the question. So, taken as a whole, I think you'll agree that the actual questions presented here are not intellectually challenging, but writing a cogent, thorough, analytical response under time constraints is the challenge presented by this pretty hard professional responsibility fact pattern.